Hi guys, this is Mr. Tan, and we are on contract law, and we're specifically focusing on really the application of the elements that we've discussed to form a contract. So, just to recap, the elements are an offer, acceptance, consideration, capacity, legality, and intent to create legal relations. And the question we have to say to ourselves is, in certain instances, what happens in terms of the applications of these elements? So, what about a counter offer? Well, we can see the case of Hyde versus Wrench in 1840, and Mr. Wrench owned a farm, and he was selling it and made an offer to Mr. Hyde for £1,200. Mr. Hyde actually rejected this offer, so Mr. Wrench then offered £1,000 for the sale of his farm, and on hearing this, Mr. Hyde then offered £950. Mr. Wrench declined Mr. Hyde's offer, and subsequent to that, Mr. Hyde accepted the previous offer of Mr. Wrench for £1,000. But Mr. Wrench actually declined the offer by Mr. Hyde. And so Mr. Hyde took Mr. Wrench to court, stating specific performance in that there was an offer and acceptance, consideration, capacity, legality, intent to create legal relations, but Mr. Wrench didn't want to sell his farm. So what was the ruling in this case? Well, the court actually, dismissed Mr. Hyde's claim because there was no binding contract for the farm between Mr. Hyde and Mr. Wrench. It was stated that when a counter offer is made, this supersedes and destroys the original offer. So the original offer is no longer available or even on the table because Mr. Hyde made a counter offer of £950. So be careful, if you are making a counter offer, you can't then go back and accept the previous offer made by the person selling you something. The next case we're looking at is to do with acceptance and to say when is acceptance made. And here we're looking at the postal rule. With this case here, we are reviewing Adams versus Linz in 1818. And, Adams was the claimant, the Linz was the claimant, offering to sell some wool for the asking price. And he requested a reply in the post. But the letter was delayed in the post, and on receiving the letter, Adams actually posted a letter of acceptance on that same day. However, due to the delay, Linz had assumed that Adams was not really interested in the wool and sold it on to a third party as you would. So Adams, sued for breach of contract. So who is in the right and who is in the wrong? Because really, Linz could, say that he didn't receive the acceptance letter, so he had no choice but to sell his wool on. But on the other hand, Adams could say that he accepted it as soon as he got it, and it wasn't his fault. It was just the letter was delayed in the post. And it was actually held that the contract was made and came into existence in terms of acceptance, because there was offer, acceptance, consideration, capacity, legality, intent to create legal relations. At the moment, the letter of acceptance was placed in the post box. So here we can see this is, example here, that acceptance was made in a specific case, establishing the postal rule. Now, the next area we need to look at, and you really need to focus on, are terms and conditions. And we really need to understand what we mean by terms and a condition, because they give rise to different remedies in terms of one of these being breached. And a condition goes to the heart of the contract, and if breached, then the remedies include to rescind or repudiate the contract, to cancel the contract, and also the possibility of claiming for damages. Whereas if a term in the contract is considered to be a warranty, then the warranty does not give rise to allow you to cancel or rescind the contract. It only gives you a recourse in terms of claiming for damages. So it's very important to understand the difference between, conditions and warranties. And this can be seen in the two cases listed below, Prasad versus Spies in 1875, where the claimant Prasad was an opera singer, and she was contracted by the defendant to perform in the capacity, for a duration of 3 months, being paid, a salary of £11 a week, and with the option of, being extended for another 3 months, with no more than £14 per week. And, she would get paid on the 14th of each month, and the scheduled performance, the launch date, was the 28th of November. Unfortunately, Prasad couldn't actually carry out the performance on the first 3 days because she fell ill. So it was really no fault of her own because she got ill. And Spies, the opera house, employed someone else to conduct the performance that Prasad couldn't do because she was ill. And then Prasad took the opera company to court, stating that they had cancelled her contract and employed someone else. When it went to court, the question was this a condition or warranty? And the judge held that this was a condition because it was absolutely essential that Prasad actually performed on the opening week, because that's what she was there for, and that could make or break the opera in terms of the performance. So it was absolutely essential that she was there, and thus this was deemed to be a condition, so the opera house could rescind the contract, and also they could claim damages in terms of having to hire someone else of £83. If we look at the second case of Bettini versus Guy, 1875, again another example of an opera singer who was employed near London, and Frederick Guy stated various conditions of the contract, which means including you couldn't perform within 50 miles to another opera house because it was very, very close to London. And he was contracted to perform between January to 1st of January 1875 to December 1875, and then a further 3 months could have been added on if they wanted to, and she was paid £150 per month. And Guy also stipulated that the tenor needed to be before the opening day, 6 days before, at the opera house performing and practicing, and that was a condition of the contract. But Bettini, when he actually came to the opera house, he only came 2 days before the start of the performance, and Guy actually rescinded the contract and actually got someone else in, stating that it hadn't met the conditions of the contract. So the question really was, was the time period in terms of Bettini having to be there 6 days before instead of only coming 2 days before the opening performance, was that a condition of the contract or a term of the contract? When it went to court, it was held to be a term of the contract rather than a specific condition, and therefore Guy couldn't actually rescind the contract, and Bettini had a case against the Guy, because in a warranty you cannot rescind the contract, you can only claim for damages. So here we can see the difference. And if you're going and you have a contract of employment, it's important to find out and to know exactly what are conditions and what are warranties, because not all the terms on there are conditions. Not all of the terms in a contract go to the heart of the contract that make it up. So it's very, very important, if you're going for the creative arts and you see all the terms in a contract, and one you don't comply with, it doesn't necessarily mean you can rescind the whole contract. So very important to apply these specific elements to it. And really the question you should be asking yourself is, does that term go to the heart of the contract? Because if it does, then it is a condition, and if it doesn't, then it really is a warranty, as seen in these two cases.